welcome to another edition of The Law and You. Today we consider the question as to whether Parliament is supreme, and that is in the context of Guyana. Now, parliamentary supremacy, or as is commonly known as parliamentary sovereignty, in UK meant that Parliament or the legislature was free to enact any law which it deemed necessary for the order and good governance of the country. There were no principles or guidelines which kept Parliament restricted to a certain power or a certain process in which it used to enact certain laws. Now we're to consider in the Caribbean whether Parliament is sovereign or whether there exists what is commonly known as parliamentary supremacy. Now, taking us back to Article 8 of the Constitution of the Cooperative Republic of Guyana, Article 8, and this is me paraphrasing, basically states that the Constitution is our supreme law. Now, it is respectfully submitted that in Guyana, the Parliament is a creature of the Constitution. And evidence of this can be found by looking at Article 50 and 51 of the Constitution of the Cooperative Republic of Guyana. In brief, Article 50 of the Constitution states or regards Parliament as being a supreme democratic organ. Article 51 of the Constitution of the Cooperative Republic says that Parliament, and this is me paraphrasing, Parliament has the power to enact any law for the order and good government of Guyana. And a case on the point of parliamentary supremacy, or as commonly known as parliamentary sovereignty, is the landmark case of Collymore and the AG. In this landmark case, Chief Justice Withing had this to say, and I quote, that if Parliament exceeded the constitutional limits, it was acting ultra vires. What does this mean? It simply means that the powers conferred on Parliament by virtue of the necessary constitutional provisions guide its day-to-day operations. Should Parliament go beyond those powers conferred on them, that law shall, to the extent of its inconsistency, be deemed null and void. As compared to the UK, where parliamentary sovereignty obtained, the courts had a limited power in the sense that they were only allowed to interpret, apply, and administer what Parliament had enacted. In the context of Guyana, should a law be outside what the constitutional provisions provide for us in terms of the powers of Parliament, that law, to the extent of its inconsistency, would be deemed null and void. Now, let us consider Article 172 of the Constitution. This is done with the aim to show that Parliament, in a sense, could be deemed to be sovereign once Parliament acts within the limits which the Constitution has provided for. A typical example of this is Parliament can use its organ and enact any law provided that such law is in conformity with the constitutional provisions. In fact, Article 65 of the Constitution says that this organ of democratic power that we refer to as Parliament has or consists of the President and the National Assembly. Now, in Parliament of itself, and this goes back to its, in a sense, supreme nature, allows for certain privileges and immunities. And it is Parliament who determines what these privileges are. One such privilege is that any member of the National Assembly who makes a comment or speaks on a certain issue within that National Assembly, no civil or criminal action can be instituted against them. Hence, in the context of Guyana and parliamentary supremacy or sovereignty, Parliament can be deemed to be sovereign only within its boundaries or limits as prescribed by the necessary articles or the relevant articles of the Constitution. So there you have it. Parliament can be regarded as being sovereign once it acts within those powers which the Constitution has conferred on this democratic organ of power. Thank you.
Audio Jungle.